Good morning. There's no way that I could do Mr. Pratt justice by trying to introduce him and his background. The issue that he's going to speak about today is an issue that has been a topic of discussion with this group since I've been involved for the last 14 years. Our federal partners are in the room, and they're always in the room with us, and thank you for being here this morning. He's going to provide us information. He's going to provide us some history. I think you'll find it entertaining, but I think you'll find it extremely informative.
I know in this audience we have people with different viewpoints. I'm glad you're here. We all pledged to uphold the Constitution, and the encroachments upon it happened before we were born. These occupations are good and honorable, but how do we restore liberty in the land? How do we restore peace and sanity to good government? Work together. BLM, Forest Service, any government agency that's represented in here, sheriffs, work together. So what shall we do? I don't know. I can't tell you what to do. I just know that I have spent 5 months trying to understand jurisdiction, and I finally got my mind around it. Were today's public lands purchased by the consent of the legislature of the states? When I was a boy, the United States Forest Service was our best friend. Now the Forest Service and BLM are our worst enemies. Sheriff Palmer asked the similar question. He said, where does the Forest Service get its constitutional authority to have law enforcement officers within Grant County? Clarence Thomas, there are really only two ways to interpret the Constitution. Try to discern as best we can what the framers intended, or just make it up. The sovereign states and subdivisions are duty-bound. They're going to draw a line, and in 1798, they called this interposition, to interpose. Hopefully you won't be offended by anything I said. Bound by oath to uphold and defend this Constitution and the Constitution of the state that you live in, that you're working in. And maybe we'll all come together, the sheriffs and federal employees, and find a harmonious solution to our problem. The state governments are to protect the Union of States from encroachments of the federal government. The state governments are to protect. We call this interposition. Peaceful way to try and take a check and balance on a federal rule or regulation or law or Supreme Court decision. Thank you. Thank you. Thank you. I'm delighted to be here. I know that there are people from different backgrounds. I welcome you also. I have an interest in the subject of jurisdiction. I'm just a citizen. I do love my sheriff's department. A tiny bit of background won't hurt. When I was a boy, 12 years old, my best friend, his father was a forest ranger, and I wanted to be a forest ranger. My other best friend, he became a forest ranger. He's still my dear friend. All these years, he's retired now, having served in Washington State and Idaho full-time for the United States Forest Service. When I was 18, I got out of my first year of college and I applied and I was accepted as a smoke jumper. And I'd had a wonderful summer and fall working for the Forest Service. I fought fires in Oregon and in Washington, and the last of the summer they sent me on top of a mountain because I had skills in building, and I built a Forest Service lookout tower. And that was a great experience for me as I look back at my youth. Some years later, my sister and her husband crashed in a horrible burning wreck in their airplane on top of the forest on Boulder Mountain in southern Utah. And killed 6 passengers. My sister and her husband, of course, fried in this burning event. And I was a corporate pilot by then, and I flew about, and we finally found them. It took us 6 weeks of searching. They were under the snow most of the time. And after the snow melted back, I met the first sheriff I ever met in my whole life. I don't remember his name, I'm sorry I don't. But this man organized the search and rescue team. They invited me to join them, and I rode in on horseback to help take care of this problem. And that was my first experience with a sheriff. I don't remember ever voting for one or even knowing that a sheriff existed before that. But I had a feeling of endearment and closeness as I watched these good people volunteer their time. At 5 o'clock in the morning, they got their horse trailers and their horses, and we rode about 5 miles up into the mountains to pick up these last remains. And so it wasn't too many months after that, I went down and met the local sheriff. And his name was Ed Phillips. Any of you remember Ed Phillips? Sure you do. He was one of the founders of the Western Sheriff's Association. And I liked Ed Phillips, and I still do. He's one of my best friends 20 years later. Well, I volunteered whatever it was. I wanted to be a part of whatever he was doing. And he said, well, you can belong to the posse. And so I joined the sheriff's posse, and we had a lot of search and rescue at that time. That was before cell phones. I guess now with the cell phone, they call for help somewhere else. I don't know. We don't get as much now, do we, Robert? But we had a lot of search and rescue, and I got to participate and to hopefully help pay back some of those great men that helped my sister and her husband. So that was my introduction to sheriffs. I had flying skills, and so I had the privilege of flying search and rescue and lots of extraditions. I remember one, we picked up a guy in Phoenix, Arizona, and he was so glad to get in the airplane. Man, he says, I'm so glad to see you guys. Now I can go home. Well, home was jail in Fillmore, Utah. He says, this place has cockroaches and the food is terrible. I'm looking forward to Fillmore Jail again. Isn't that great, guys? Well, that's some of my experiences, and it's been a happy one, both in the Forest Service and with the sheriffs. I have a very touchy subject today, touchy because I know there are sensitive feelings about this message. And so as I present Untangling Federal Jurisdiction, try to have an open mind. Some of my material is from newspaper articles. It's from interviews. I don't know how accurate and honest the interview people were, and some of it's from books, heavy reading. It's been months and months of heavy reading for me. I wanted to. I felt motivated to. And so join me in this search of history and see if we can learn something from it. It's in 3 parts. Part 1 is Recurrence to First Principles. Now, I'm not new at First Principles. Many years ago, I graduated with 2 degrees from universities. I taught school for 6 years. And then about that time in my life, I met this grand old scholar. He was an old man. He was 65. And I thought, boy, he's old and smart, for that. I was a young guy. I was about 35 then. And his name was W. Cleone Skousen. He served 4 years as chief of police of Salt Lake City after serving 16 years in the FBI. And he taught some lessons called The Making of America. It's the story of America, about first principles. And the thing we were so excited about was what these principles were. I'd never heard them before in my life. I had 2 college degrees and graduate work at Berkeley. I went to Berkeley in the 60s. And even remember Berkeley? The University of California at Berkeley in the 60s was nothing but hippies except for me. Anyway, that was my background in education. And yet I went to these classes on American history, and it was just thrilling to hear about the principles of liberty. And so after 2 years of studying with my professor, one day he says, why don't you come to work for me? I need more help in research and teaching. I get too many invitations. I can't keep up with them all. So I had the wonderful privilege of joining his think tank. And his think tank's still alive and well today, even though he's long deceased. It's called the National Center for Constitutional Studies. Google NCCS, and you'll find out where I started. The very first project was this book, The 5,000-Year Leap. Freedom principles all the way through, 28 of them, principles of liberty. The second big project was this one, The Making of America, the substance and meaning of the Constitution. And so we spent 7 years, and these were the 2 main products of our labor for those 7 years. In 2006, we reprinted the 5,000-Year Leap. It hadn't done very well for some reason. People didn't seem to be interested in liberty. And yet in 2006 it started to sell. And by 2009, in March of 2009, just 3 years ago, it was the #1 national bestseller. Did any of you ever read it? Come on, let's see. Anybody read the 5,000 year? Good for you. Got 2 hands come up. Thank you. Well, this is great reading. What is it? Fundamental Principles of American Government, the Basic Principles of Liberty. Well, why would we want to know that? Don't we want to know the Supreme Court cases and the federal acts of Congress instead? I suggest we look at liberty first. Let's take a look at it here. One more thing before we start on the liberty discussion. If we don't know what jurisdiction means, let's get on the same page, okay? In Black's Law Dictionary, there are 4.5 pages of definition of the word jurisdiction. So let's go by the definition that comes up, #1. This is what we mean when we say jurisdiction today. A government's general power to exercise authority over all persons and things within its territory. That's the very first definition, followed by 4.5 pages of fine print further defining it. I was impressed and strengthened when I received a 10-page letter from Sheriff Gilbertson. Now, he didn't send it to me. One of my friends from a neighboring sheriff's department sent it to me. And he said, "Tell me what you think of this." Now, Sheriff Gilbertson put a lot of effort into trying to read and trying to understand the history and the background of our country and the duties of a sheriff. And I read it carefully, and I thought, well, this needs some help, but I was impressed with his effort. And I started to study in October of last year the topic of jurisdiction. He asked the question, where does the United States Forest Service get its authority? And then he tried to answer it. And like I say, I thought, well, he needs some more help on that, but I want to know, where do they get their authority? I'd never even thought of it before. Sheriff Palmer also wrote a letter, and I got that later on, and he asked the similar question. He said, where does the Forest Service get its constitutional authority to have law enforcement officers within Grant County? Where does it come from? It's a legitimate question. In January 12th of this year, there was a meeting in Oregon, which I read the report on, and the meeting was held between the Oregon Sheriff's Association and the Department of Justice and the United States Department of Agriculture's Forest Service office. These are some of the people that attended. We had Amanda Marshall, the United States Attorney. We had Washington County Attorney Elmer Dickens, and of course a number of sheriffs from Oregon. These 2 we just quoted from. They asked their questions, and Sheriff Palmer said it went around and they didn't come up with a satisfactory answer, and finally they went on to the next question. So that wasn't the place to get the answer to that. Sheriff Gilbertson sent me an email 2 days ago when I asked for permission to quote him today, and in that email he mentioned this, and I thought it was worth reviewing. What bothered me the most regarding the conversation in Portland with the U.S. Attorney's Office was that they did not want to talk about the Constitution, but rather put all their confidence in the Supreme Court rulings. They even referred to the supreme law of the land as the Supreme Court, and were visibly upset that I would object to that notion. Now, he expressed this feeling that he had, and just, I say, a couple of days ago, and gave me permission to quote from his letters. Elmer Dickinson wrote an excellent summary of the meeting, January the 13th. He dates his summary and sent it out, about 4 pages. Good reading to see what went on at this sheriff's and federal meeting. And in that statement he wrote, it appears that the sheriff, Gilbertson, does not believe that the U.S. Supreme Court has the authority to interpret the meaning of the U.S. Constitution. Now that's somewhat of it. Sounds like the tone of that suggests to me that this is a disappointment to Attorney Dickens that the sheriff didn't accept Supreme Court decisions as the final say on what the Constitution means. He went on to write, there are many Supreme Court cases going back over 100 years. The federal Congress, well over 100 years ago, and then he gives the legislative acts and the court cases for the past 100 years, a little sampling of them to show that Gilbertson ought to think that these things are acceptable interpretations of the Constitution. He goes on, to put it bluntly, the opinion that federal agents do not have jurisdiction on federal property located within the state of Oregon is without support in law and is meritless. Now, that was the opinion of the attorney. The Supreme Court, let's take a look at them for a minute. Like I say, many, many years ago, I started studying the topic of liberty, and the question of the Supreme Court and Supreme Court cases came up. How trustworthy are the decisions of the Supreme Court? Are they trustworthy? Do they always come up with the Constitution's original meaning? Or do they sometimes make up things themselves? Let's take a look at this. Here's one man. He is a justice on the court still today, as I recall. We can see him right over here, Clarence Thomas. He was asked this question, and he responded. There are really only two ways to interpret the Constitution. Try to discern as best we can what the framers intended, or just make it up. And then he went on. Unless interpretive methodologies are tied to the original intent of the framers, they have no more basis in the Constitution than the latest football scores. Well, that's pretty straightforward from a justice of the Supreme Court. Either you follow the original contract, or you just make it up. And I assure you that many times they just made it up. Let's take some interesting examples of this. Here's the Supreme Court. Clarence Thomas is looking over at Stephen Pratt. Now, Stephen Pratt is one that's well known for his living Constitution belief. The Constitution means what the Supreme Court says it means, and that's all. And so, as Justice Thomas looks over here, I don't know, everybody else is looking up to the front, but for some reason Clarence Thomas is looking over at his friend, I hope, Stephen Pratt, and I think he's probably thinking, they just make it up, because so often they do. In 1985, when we came out with our book, The Making of America, it's actually broken down into 286 principles. Principles coming from the Constitution that will help us understand the substance and meaning of the Constitution. For each principle, our research staff was assigned to find 3 to 5 quotations from the authors, from the founding fathers, explaining what it means. Instead of giving our editorial viewpoint as to what it means, let these old-timers that were there at the convention explain what it means. That was our project. The book still is in print, sells very well, and it'd be good for some people that would like to know original intent, perhaps to review these early statements. On page 255, the author, the man that put it all together, Cleon Skousen, wrote, "The Supreme Court began reversing previous Supreme Court decisions by the bushel basket." Now, that's not a term I'm familiar with in law. How many Supreme Court cases fit in a bushel basket? I guess just one if it's big enough. Anyway, he's using this term to help us understand that the Supreme Court wasn't consistent. I remember the old professor on several occasions telling us that the Supreme Court had reversed more than 150 decisions on natural law, where the case was turned over and a new decision was made. And so to say the Supreme Court is reliable and trustworthy in the area of constitutional interpretation is not a very clear and accurate statement. Well, but that's not all. Good lawyers have written on this. The Supremacist, The Tyranny of Judges and How to Stop It by Phyllis Schlafly. Good reading. You can go online and read it for free. Men in Black by a good lawyer named Mark Levin. How the Supreme Court is Destroying America. Now, if you want to brag on the Supreme Court, give a chance to these lawyers. Let them share their thinking also. They have hundreds of pages of good documentation to review before you make that final decision on how reliable they are. United States Attorney Marshall did a fine job of presenting in this letter her perspective. And I read it and found value in the good quality of her viewpoint. In this letter on January 23rd, and this is the one I got permission from Sheriff Gilbertson to quote, it was a personal letter to Sheriff Gilbertson, Attorney Marshall declared, "Supreme Court precedent for the past 100 years is clear. Under the Property Clause, Congress may delegate rulemaking authority to its federal agencies." How trustworthy is Supreme Court precedent? How trustworthy is their interpretation of the Property Clause? Now see, everything hinges on the Property Clause when we talk about the when we talk about the United States Forest Service, or we talk about the BLM, or any number of other agencies. It's the Property Clause on which this all hinges. How trustworthy is the Supreme Court opinion? Your position, she wrote to Gilbertson, is incorrect, 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 erroneous. You are on a misguided course. Now, maybe he is. Maybe she's right. Let's review and let's ponder and think about this. It is your constitutional duty to promote respect for federal laws in your county, particularly when validated by the Supreme Court, whether you agree with them or not. Now, I read this and I thought, you know, this reminds me of the old box thing. You've heard, you're supposed to think outside the box. Well, I thought, you know, what they really want us to do is think inside the box. And if that attorney were writing an oath of office, it would probably read something like this. I swear to uphold and defend the federal laws and regulations, particularly when validated by the Supreme Court, whether I agree with them or not. Now, is that what we swore to do? That's not what I swore to do. I swore to uphold and defend the Constitution, whether the Supreme Court agrees with it or not. By oath, is a sheriff duty-bound to question the constitutionality of federal laws and court decisions? If a court decision asks you to violate the Constitution, are you duty-bound to consider and decide what to do? I hope you feel that you are. Sheriff Cleveland was duty-bound. Sheriff Cleveland took his oath in 1871. He earned a reputation as an honest sheriff and a fair sheriff. He did not ask his deputies to do anything he was not willing to do himself. Sheriff Cleveland. You ever hear of him before? Sheriff Cleveland later became the President of the United States. He was 33 when he became sheriff, 49 when he became president. He was not only the President of the United States, he was the 22nd President and the 24th President. And no one had ever done that before. He was also the only president that got married in the White House. He married a young woman. She was 22, he was 49, and they raised a family of 5 children. Grover Cleveland was faithful to the Founders' Constitution and to what he believed were God's commandments and common sense. He vetoed 584 acts of Congress. Does Congress always follow the Constitution? Is there any check and balance against a Congress that violates the Constitution? Yes, there is. The check and balance, one of them, is the president has the power to veto. Now, some laws are constitutional and they're still bad laws. He judged both kinds and vetoed 584. One of the laws that Congress had passed was to send cash to the drought-stricken farmers of Texas. They were going to send $10,000 to the drought-stricken farmers of Texas. Now, isn't that a noble thing to do? We're going to send money to those poor farmers down in Texas. Is that in the Constitution? He had to decide that. He decided no. And here's what he wrote in his veto of that particular act of Congress. I can find no warrant for such an appropriation in the Constitution. That was a very courageous stand he took. Well, later in years, after serving 2 terms as president, not consecutive, he wrote, I ought to have a monument over me when I die, not for anything I have ever done, but for the foolishness I have put a stop to. Now, we as sheriffs can do the same thing. We can put a stop to the foolishness to some of those things. The Freedom Index is another way we can determine how Congress is doing. If we're going to rely on the acts of Congress and the Supreme Court, they need to be constitutional. If they're not, then we ought not to support them. We ought to, in fact, find ways to try and overturn them peacefully. How constitutional are federal laws? There's a magazine called The New American. Every 6 months they publish the Freedom Index, in which they put 10 issues that were currently passed in Congress. Not passed, voted on, I should say. They were voted on in Congress. And the editor and the staff, they try to decide, did they vote constitutionally, according to the original intent of the Constitution? They call this the Freedom Index. In January this year, they issued House, Senate average score on 10 measures. Do you have any idea what their average score would be in support of the original intent of the Constitution? Would you believe 44%? That's the average score supporting original intent of the Constitution. Well, if we go into Congress and we say 44% correct, I used to be a college teacher. I used to give tests. You went to school. You took tests. What was passing? What was an A? Well, wasn't it like 90 to 100 is an A, 80 to 90 is a B, 70 to 80 is a C, 60 to 70 is a D. Oh, what's the one below that? Yeah, that's the score Congress earned in January of this year in not following their oath of office. Think inside the box is what it appears some of the attorneys want these sheriffs to do. And inside the box, they have things like the Supreme Court decisions and act of Congress over the past 100 years. They have the United States Code. They have CLEPI versus New Mexico. They have FLIPMA. They have the Federal Register, pouring new pages into the box at the rate of about 200 new pages a day. And, of course, the Code of Federal Regulations. These are the things in the box. And they say to the sheriffs, think inside the box. Just look in there and follow that, and if you don't agree with it, follow it anyway. Really? I'm going to take you now on an adventure. That was the introduction to the adventure. The adventure is to think outside the box. Isn't there something more to my office than just thinking inside this box with these acts of Congress and Supreme Court decisions? Let's go back a long time and think outside the box. Now, we all have respect, I hope we do, for the old philosopher Benjamin Franklin. Sometimes these old-timers had some wisdom. Let's look at this suggestion. A frequent recurrence to fundamental principles is absolutely necessary to preserve the blessings of liberty and keep a government free. Recurrence to fundamental principles. There's another old-timer, Patrick Henry, great statesman, great American. He declared, "No free government or the blessing of liberty can be preserved to any people but by a frequent recurrence to fundamental principles." The Supreme Court in 1810, this is more than 200 years ago, the security of a people against the misconduct of their rulers must lie in the frequent recurrence to first principles and the imposition of adequate constitutional restrictions. So we need to follow first principles, fundamental principles, and we have to have adequate restrictions in the Constitution to keep the federal government and the state governments from encroaching upon us. Winston Churchill had this profound wisdom here. The further back you can look, the farther forward you are likely to see. Now, what does that mean? The further back you can look in history, the further forward you are likely to see. Let's take a look way, way back and then bring ourselves up to understanding jurisdiction. We're going to go so far back that you'll wonder, why are we going back there? Let's take a look at it. We should have been taught this in the 7th grade, but we weren't. This is ancient Rome, the Roman Empire. The year is 9 AD. And Caesar has taken control of many, many states, the countries around him. And now he looks at this northern area up here called Germania, and he thinks he needs to take control of Germania also. There are 3 words that describe, or 3 phrases that describe the kind of government that was being practiced then: Roman civil law, Roman law, and civil law. Now, for simplicity today, we're going to talk about Roman law. Now, every time Caesar was taken down the parade route in his big sedan chair, somebody out in front on a pillow was carrying a thing called the fasces. Now, the fasces was a bundle of sticks held together by a blood-red cord with a battle axe tied to the side. This was the symbol of authority of the central government run by Caesar, and it was a very important symbol. The Roman law in the days of Caesar included some of these character traits: all-powerful central government, national sovereignty, tax and control everything, watchdog everyone's business, promise prosperity and greatness, and fight wars anywhere on the earth. Does any of that sound familiar? These were the principles of Roman law, practiced in the year 9. Well, now they decided to take Roman law to Germania, and so they organized 4 legions of Roman soldiers. Actually, 3 legions and 1 auxiliary legion with 5,000 hardened troops in each legion. That's 20,000 hardened troops marching in to take control and take jurisdiction over Germania. Well, the battle lasted for 3 days. You see, there was a certain group in Germania that didn't like the idea of being encroached upon. They didn't want to be a part of the Roman Empire. They didn't want to be under the jurisdiction of Rome. And the organizer of this battle, in this well-known painting right here, this guy right here, when he went to Rome and trained as a Roman soldier, his name was Arminius. When he got back to his home, they called him Hermann, Hermann the German. Well, Hermann organized the local militia, and he knew how Romans fought and what their tactics were, and so he was successful. And they were able to stop 20,000 hardened troops. It took 3 days of hand-to-hand combat, and when the battle was over, there were 19,000 dead Romans, and the other 1,000 were fleeing for their lives. We will rule our own territory, is what they were trying to express to Rome. We will have jurisdiction ourselves. Now, in the year 450, 2 brothers came to England. We're going to find out what the significance of this is in our lives in a few moments. They were Germanic brothers, and they entered England, and they brought with them Anglo-Saxon common law, the guardian of freedom. That was the character, that was the thing that they were preserving, and the Battle of Hermann was part of that. Freedom wasn't going so well in 1215. In 1215, the king had organized a powerful central government. The barons, however, had also had some power, and they finally got the king to sit down because he was fearful for the war that was about to happen, and he signed the Magna Carta. Now, if you've never read it, take time. You can Google it up and read it. It's great freedom history, and it'll help you to understand American freedom and liberty. Well, the Magna Carta was to be sent out to each of the English counties and to be read to all freemen. If we likened this government to ourselves, the king would be similar to our central government today, and the barons who presided over the baronies would be similar to our states. So the states were imposing the power on the king. They were compelling the king to respect their states' rights. Here's a phrase or two from the Magna Carta that might be interesting to you. That's how it looks. That's a picture of it. Quite a colorful document. The baronies are represented around the sides here. And this is the king's seal, that he pledged he would uphold and defend the Magna Carta. Well, that's like pledging you'll uphold and defend the Constitution, and then you don't. Well, he didn't. He was only good for about a year, and in a year he was dead because of the battles and the conflict that went on in his country. But here's some of the things he promised to do. All forests that have been created in our reign shall at once be disafforested. Now, that doesn't mean they're going to cut the trees. That means the king is going to take his authorities out of the forest and turn them back over to the baronies. Riverbanks that have been enclosed in our reign shall be treated similarly. I believe they call those riparian areas today. We're going to take all of the central government's authority out, and we're going to put in local authority. The Magna Carta goes on. All evil customs relating to forest and warrens, I believe the warrens were the game preserves, foresters, warreners, that's like game wardens, sheriffs and their servants, or riverbanks and their wardens, are at once to be investigated in every county and are to be abolished completely and irrevocably. They're going to take the authority back to the barons, or to the baronies, proper terminology, and not have the central government manage their forest and their game preserves. This was old history. This is back in the year 1215. In Germany in 1875, the German people thought it worthy of their money and time to build a monument to Hermann. He had done something great and wonderful, and so they built this great monument. Now look at can you see the people down here, how small they are? They look like ants. They're up here, people standing around this observation deck. Do you get a feel for this? Hermann's sword is 23 feet long, so Hermann's pretty big. Hermann, by the way, I was there. I looked up at Hermann, and you know what I was thinking when I looked up at him? I didn't have any interest in Hermann at all. I didn't care what Hermann did. I was about 20 years old, and I'm sure I was more interested in when is lunch? Something like that. Hermann did something very special by stopping the encroaching Roman armies. He preserved what later became known as common law. Common law was the law of the people. It was law based upon the power in the people. And Two of the phrases coming from the Declaration of Independence that you're familiar with: higher law, laws of nature, and of nature's God. These were the foundation concepts that people's law was built upon. Now, in contrast to Roman civil law, which was built upon coercion and a powerful central government that would use coercion if necessary to attain its goals. They based their government on political law. Whatever the government says, whatever the Supreme Court says in today's terminology, whatever Congress acts upon, that's the law. Now, that was the Roman law. That's what was driven out and stopped at that time in Northern Europe. There are two fundamental principles of common law, or people's law, very elementary. Do all you have agreed to do. Do not encroach on other persons or their property. That's it. American law is based upon these two fundamental principles. In the old days when we were children, our parents taught it, our school teachers taught it, in words something like these: keep your promises. Don't hit other people or take their stuff. So Herman's facing Rome. He has his 23-foot sword in the air, and he's thinking, Rome, go home. Preserve our principles. Now, these principles, these ancient principles, were so important to Thomas Jefferson that many years later he wrote, Restore the Ancient Principles. And when he was speaking of ancient principles, he was talking about the principles from Anglo-Saxon common law and also the principles of the Old Testament that are very similar, almost like the two people knew each other. Ancient principles. He first refers in his writings to the principles of ancient Israel and how they based government on people, and that the government distributed its power among the people. For those that are Bible scholars, remember the story of Moses when he was visited by his father-in-law Jethro. Jethro watched for a few days. Moses had led a large number of people, and the Bible scholars say probably at least 3 million. Do we need some form of government with 3 million people? We do. And Moses hadn't structured a government that he could handle at that time. His father-in-law watched, and he said to his son-in-law, Moses, my son, what thou doest is not good. Thou wilt surely wear away both thyself and this people that is with thee. And then he explained to Moses that he needed to divide up the responsibility and delegate power so that other people could take their share of responsibility. And the Old Testament explains they divided the people up into groups, 10 families, 5 groups of 10 families, 50 families, 2 groups of 50 families, 100 families, 10 groups of 100 families, 1,000 families. And so they divided into different levels of government. And each level was instructed to choose their leader, choose their best, their wisest leader to be their governing officer. They did that. And it gave Moses the chance to have a little rest. And he had, I calculated once, if you had 3 million people and you divided in this structure, you would have 75,000 new helpers to help administer government at the county and local levels. People's law, they called it, people's law. And then historically, as it came to America, it was eventually called common law. Anglo-Saxon common law apparently derived from this. There's not a good historical connection that I've been able to find, but the similarity is so high that we think that it probably had some connection somewhere. Anglo-Saxon common law was based on the group called the tithing. The tithing was about 10 families, and they chose a leader, and their leader was called the tithing man. And 5 of those groups of 10 would join into a village, and they would have a level of government called the village or the ville, and they would choose a leader called the ville man. And 2 of those groups would organize into the next level of government called the 100. And you guessed it, the leader was called the 100 man. And then they'd organize several hundreds together, and they would have a shire. And they called it the shire, and over that shire was the shire reef. And you've heard that part of the story before. Roman law had a symbol, and the symbol was the fasces. We need a symbol for common law or people's law. Back in this time period, Thomas Jefferson and others were invited to create artwork for a great seal. He wrote in his journal what he suggested, and then an artist conceived it and drew the picture. Thomas Jefferson suggested the Great Seal of America should be the children of Israel being led by God's pillar of fire on one side, showing the influence of Bible on our form of people's law, and on the other side, we should have the heads of Hengist and Horsa, the two Germanic brothers that came into England in the year 450 and brought with them Anglo-Saxon common law. He felt these were great symbols of American liberty. So we'll use one of those symbols to represent the two contending viewpoints. The king in this old illumination is in the center. Beside him is standing the reef, and they're carrying out some form of capital punishment, it appears, in this illustration. And the reef was responsible to collect the taxes and keep peace in the shire. And of course, they call him the Shire Reef, from which our word sheriff derives. We've had many sheriffs in America starting early on. In 1634 in Maryland, in 1651 in Virginia. By 1850, the territory of Utah, now I'm going to use Utah because that's my home state. All of your states in the West will have a similar story. You will have had a territory, something will have happened in that territory to eventually achieve statehood. Your stories will all be very similar to the Utah example. The Utah Territory in 1850 looked like this, and they wrote the Utah Territorial Act. And the same is hereby created into a temporary government by the name of the Territory of Utah. Now the key word here is temporary government. This was not intended to be a permanent thing. It was temporary until there were enough people and enough desire to become a state. They would have a temporary government. Now, by 1894, the territory of Utah looked like this, and this is the outline of it today. A territory plus people plus governance can become a state, and the people about this time were yearning to have statehood. They wanted to have the same rights and privileges as the other states in the Union, and so they started to appeal to have statehood. One of the steps of becoming a state was to write an enabling act compact. They call this the Enabling Act. Now, a compact is a contract between states, and they were making this contract with this proposed new state. They were making it with the rest of the states, and the rest of the states were represented in Congress by their representation. Note, as of March the 7th, 2012, it appears there are still 7 violations of the compact on the part of the federal government. The compact was never completed, and you'll find that in the western states, and when I say western states, I'm including Alaska, in the 12 western states, the compact was never completed. In Utah, in 1896, following the Article 4, Section 3, Clause 1 of the Constitution of the United States, this is called the Admissions Clause, new states may be admitted by the Congress into this union following the Admissions Clause and the procedures in the Enabling Compact. They established the Utah State Constitution. Now, this is a good place to introduce the Jurisdiction Clause family. I'm a school teacher, and I try to find ways to illustrate and present that people can remember. Hopefully this is useful. The Jurisdiction Clause family has 7 members. The Admissions Clause we just introduced. There's Claims Clause, Property Clause, Enclave Clause, Engagements Clause, Supremacy Clause, and Guarantee Clause. We'll go through each of those clause members as we proceed in the 3 parts of the lesson. A truism. We may only delegate to government that which we have the right to do ourselves. In Utah, they now had a new constitution. They had been accepted as a state, and the state legislature and the governor and the judicial branch started working on laws. And they have the power now to do laws that are justified under this basic truism. They passed laws to protect life, liberty, and property. And early on, they passed the laws to establish a county sheriff. In our state, those are the numbers that established this office. A legal dictionary defines the sheriff as a creature of law created by the sovereign power in the state. In 1997, there was a court case, a Supreme Court case. It's a valuable and important court case. It was taken by sheriffs, Prince and Mack, and they went clear to the Supreme Court, and it's worthy of reading and reviewing. It was a success and a victory accomplished by 2 diligent sheriffs that thought outside the box. Justice Antonin Scalia wrote the majority opinion. In there he wrote, "It is incontestable that the Constitution established a system of dual sovereignty." Now, whenever I read a book or read anything, I have my pen handy here. I mark prolific marginal notes. I circled incontestable, and I underlined dual sovereignty, and I put a question mark over here, because I think it is contestable. There is more to the story than just saying we have a system of dual sovereignty. Did the United States Constitution establish a system of dual sovereignty? He went on to write, "Although the states surrendered many of their powers to the new federal government." Okay, I made marginal note. Did the states surrender many of their powers to the new federal government? Now, this is the Justice of the Supreme Court writing the majority opinion, which means that a majority of the court agreed with him. Did they surrender many of their powers to the new federal government? No, they didn't. And we can show you in history that this is an erroneous statement. In the Tea Party movement, they sent out a letter a few months ago that read, "Current choices in Washington, D.C. are a grave threat to our national sovereignty." What is national sovereignty? Did the United States Constitution establish national sovereignty? What is state sovereignty? We cannot understand jurisdiction if we don't understand what sovereignty is. Is there dual sovereignty or isn't there? Is there national sovereignty or isn't there? Is there state sovereignty? What is this word? It's a troublesome word. Hamilton, one of the famous founding fathers, at the Constitutional Convention declared, "Two sovereignties cannot coexist within the same limits." Oh, really? Now, maybe he's not telling the truth, but then maybe he is. If this is true, what he is saying is, in other words, state sovereignty and national sovereignty cannot exist at the same time. Now, I tend to believe that he's right, and I've come to that conclusion after the years of study. Two sovereignties cannot coexist within the same limits. Then he went on to say, "We must establish a complete sovereignty in the general government. The general power, if it preserves itself, must swallow up the state powers." Really? That ought to turn on a red light. The general government, this is Roman law, see? He's speaking as if he's thinking in terms of Roman law. The general government, by coercion if necessary, must swallow up the powers of the local government, the state government. Thomas Jefferson had a different viewpoint. These were two opposites in their thinking. Thomas Jefferson in 1824, and I noticed the year here because now he's an old man, and he's supposed to have a little wisdom under his belt by now. He wrote, "Men by their constitutions are naturally divided into two parties. Those who fear and distrust the people and wish to draw all powers from them into the hands of the higher classes, and those who identify themselves with the people and have confidence in them. In every country, these two parties exist. With other words, there are two contending forces, and it was this way from the beginning. One force believes we, the people of the United States, is a nationalist system." That was Alexander Hamilton and Gouverneur Morris and a few others. It was a limited viewpoint and not the majority by any means at the founding of the country. The other force believed we, the people of the states of New Hampshire and so forth, are a federative system. These are two opposite perspectives. Here are some of the famous nationalists: Alexander Hamilton, John Marshall, Gouverneur Morris, Abraham Lincoln, Joseph Story, Daniel Webster, and a long list of other prominent people. They believed in a strong central government, by coercion if necessary, and the states would serve as administrative agencies to the government. They would be well fitted with this symbol to guide them. This is the firm, controlled central government symbol of Roman law. Remember the Roman law? All-powerful central government, national sovereignty, tax and control everything, watchdog everyone's business, promise prosperity and greatness, fight wars anywhere on earth. News release, August the 14th, 1866. Andrew Johnson was president now. He was the 17th president of the United States following the assassination that had just taken place. They had a great political rally. The political rally was the rally of the political party under which he won his office. And the political party was called the National Union Party. The National Union Party declared victory at this great political convention. They declared the absolute supremacy of the national government. Now, that's a pretty strong statement. You need to read the whole thing so you see the rest of the context, but this is the direction they were going. They were called nationalists. They wanted the power to be in the bundle of sticks held together by coercion, if necessary. It was a nationalist victory. In later years, these people with this kind of thinking started erecting monuments. Here's one of the famous monuments many of you perhaps visited. In 1914, they erected this monument with a great throne, and under each hand of the 16th president, they placed the fasces, the symbol of Roman law. As the years went by, one of the authors of history, Greg Duran, decided to write the story. And in 2006, he published it. Did a great job collecting the evidence and the history of that portion of our country. He called it America's Caesar, the decline and fall of Republican government in the United States of America. Now, don't pass judgment by the title. Do your homework and see if he's correct. In 1916, the nationalists placed the symbol of Roman law on our coin. We see it here complete with the battle axe. In the halls of Congress, this is a picture inside where Congress meets. They're in fact raising their hand in this picture to uphold and defend the Constitution. And then they get a score of 44%. If you look straight into the speaker's stand where the President of the United States often gives his State of the Union address, you see we still are highlighting the Roman civil law, the fasces hanging on the wall on both sides of the speakers. Why are we doing that? Why don't we have the heads of Hengist and Horsa or some other symbol of liberty instead of a symbol of oppression? On the postage stamp that you're now viewing, we have Hitler and Mussolini at the height of their glory. And you can see on the left-hand side, they've chosen the fasces as their symbol of authority. There were two contending forces, and they've been with us from the beginning. One believed in sovereignty of the national government. The other believed in sovereignty of the individual states. Now here some of the people that believed in state sovereignty. Thomas Jefferson, Luther Martin, Patrick Henry, George Mason, St. George Tucker, John Taylor of Caroline, and probably we don't know much about most of these people because they lost. They lost in the war of words in the discussion on which form of government would be best. So we can hardly say, with the exception of Thomas Jefferson, what do we know about him? What do we know about the ancient principles that he wanted us to preserve? Nothing. Nothing as an American society. All we know is that on the 4th of July we eat hot dogs and hamburgers out in the backyard, and we sometimes mention Jefferson and the Declaration of Independence. But we really don't know the principles that he was trying to preserve. These other men, they're virtually forgotten. Well, with this exception, you might think of one phrase from Patrick Henry. What is it? Somebody brave enough to say it out loud? The other believed we should be a compound republic with voluntary membership. News release. Legislature passes a bill to teach U.S. as a republic. Hey, notice that date. That's tomorrow. 1 year tomorrow, the state legislature of Utah passed a bill in which they declared a bill that would ensure Utah students learn the U.S. is a compound constitutional republic, not a democracy. Can you believe that a state legislature took time to do that? And that was a big discussion that went on for weeks. And finally, when they had the vote, there was not a dissenting vote. And they told the schools, stop teaching that America is a democracy and start teaching the truth. We are a compound constitutional republic. That was beautiful wording. I'm proud of them. This man, Abel Parker Upshur, was the Secretary of State, a fine lawyer and attorney in his day. He wrote in 1840, a rebuttal of Joseph Story's commentaries on the Constitution. Now, we all think of the great Joseph Story. Anybody that knows anything about the law all knows about Joseph Story's commentaries on the Constitution, considered one of the great presentations. This man said, there are some things in there that are false, and I'd like to explain that to you. And so he wrote this, The True Nature and Character of Our Federal Government, a critical review of Joseph Story's commentaries on the Constitution. Now, this is really profound, what he had to say. In order to a correct understanding of the Constitution, it is absolutely necessary to understand the situation of the states before it was adopted. This is the situation of the states before the Constitution was adopted. Now, I took the map, I took an X-Acto knife, I cut each state apart, and I pulled them apart a little bit and glued them on a piece of paper and put it into the slide. So we can see they're distinct entities. A great new nation was not born on the 4th of July. 13 separate, distinct states, separate, distinct republics were born on the 4th of July. 13 separate nations, 13 separate countries were born on the 4th of July. It was some years later, when they confederated, that they became a union of states. 13 separate free and independent republics called states. You can also call them commonwealths. That's another acceptable term in that time period. The sovereignty of the states, written in 1910 by Walter Neal, explains, in wresting the power, or what is called the sovereignty, from the crown, it passed directly to the people. It passed directly to the people of each colony, and not to the people of all the colonies in the aggregate, to 13 distinct communities, and not to one. Those 13 distinct communities were invited to send representatives to a convention. There was no coercion. It was free will. If they didn't want to send representatives, they didn't have to, because they were free, separate, sovereign, independent countries. The First Continental Congress gathered, and only 12 of the 13 chose to send representatives. One of them didn't want to. The Second Continental Congress, they all sent representatives. These representatives were defined in that day in their dictionary as foreign ambassadors representing sovereign nations. And they came together to discuss common problems. On October the 10th, 1780, the Continental Congress passed the Resolution of 1780, removing the only obstacle to a final ratification of the Articles of Confederation. Now, the Articles of Confederation was the first effort at having a confederation to solve common problems. The Second Continental Congress worked it up. They completed it in 1777. There was a big hang-up. They didn't know what to do with the western lands, all the lands over the Allegheny Mountains. What should we do with all these lands out there? And they finally resolved that. And they resolved it in this resolution of 1780, which presents or teaches, beginning with the resolution of 1780, the Federal Trust respecting public lands obligated the United States to extinguish both their governmental jurisdiction and their title to land that achieved statehood. Now, they were obligated by trust to extinguish jurisdiction after the land became a state. 1780. That then gave them the privilege of going ahead the rest of the states and accepting the Articles of Confederation, in which they wrote another obligation. Each state retains its sovereignty, freedom, and independence. And down here we see the word delegated powers. When Justice Antonin Scalia wrote of surrendered powers, he would have been better to select the word delegated. They are not the same. Delegate means to send with a trust or commission to act for another. Delegate is temporary. It's like the loaning of a power. Surrender, on the other hand, is to yield, to cede, to give up, to grant. It's permanent. I surrender. Okay? They're not the same. We did not surrender any powers to the central government. We delegated powers to the central government. In the Convention of 1787, they called it the Convention of States. Later on, we called it the Constitutional Convention. They came up with a document, a Charter of Liberty. They shared it with the states to see if they would ratify it. Some of the principles that pertain to jurisdiction that we want to review in our message today. The new federal government is an agent serving the states. The delegated powers are few and defined. All powers not listed are retained by the states or the people. The resolution of 1780 formed the basis upon which Congress was required to dispose of territorial and public lands. All laws shall be made by the Congress of the United States. That means the Supreme Court doesn't make laws, the executive branch doesn't make laws. All laws are made by Congress, and they must be within the scope of the delegated powers they receive. That's the end of part one. Thank you for your attention. We'll take a 10-minute stretch and then we get into part two.